Inheriting a home here in San Luis Obispo County and you didn't have a trust? Before you make any decisions, you need to understand California's probate process. The wrong steps could delay your sale by months or cost your family tens of thousands of dollars. Hi, I'm Owen Schwaegerle. I'm a Cal Poly alum, real estate broker, and certified trust and probate specialist right here on the Central Coast. My wife Camille and I have helped dozens of families buy and sell property over the years right here in San Luis Obispo County. If you simply want access to our free probate guide, you can access it in the link below in the description. Today, I'm breaking down the exact timeline, costs, and key decisions that will determine whether probate is smooth or stressful for your family. Let's dive in. So let's start with the basics. Probate is the court-supervised process of settling someone's estate after they pass away. Here's how it typically works in San Luis Obispo County. Step 1. Someone files a petition with the San Luis Obispo Superior Court to open probate. In the best case scenario, within 5 to 6 weeks, you'll get a hearing date that gets published in the Tribune or Times, Press Recorder, or another local news publication. But realistically, it often takes closer to 3 months depending on the court's calendars. Step 2. At the hearing, the judge issues what's called letters of administration and an order for probate. This officially appoints the personal representative. We call them the executor if there's a will, or the administrator if there isn't one. This person becomes the key decision maker for the estate, including when it's time to sell the property. Now, once that personal representative is appointed, the real timeline begins. Here's what must happen within specific deadlines. Within 90 days, you've got to notify 2 important state agencies: the California Franchise Tax Board and the California Department of Health Care Services, or DHCS. This alerts the state that the estate exists and may have tax obligations or Medi-Cal recovery claims. And here's something most people don't know: even if your loved one never used Medi-Cal, you're still required to notify DHCS. If you skip this step, it can create massive delays down the road. Within 120 days, you need to complete an inventory and appraisal of all the estate's assets, notify creditors, and handle any claims against the estate. Now here's the good news. You can start the process of selling the home as soon as the personal representative is appointed. That means we could potentially have the property listed on the MLS within 24 to 72 hours of getting the court's approval. But, and this is really important, there's one key factor that determines whether you can actually accept an offer right away or get stuck in court proceedings for months longer. And we're gonna get to that in just a minute. But first, let's talk about money, because probate is not cheap. California law sets statutory fees based on the value of the estate. Rather than bore you with the exact formula, let me just give you a real example using numbers that are pretty typical for our area. For a $875,000 home in San Luis Obispo County, which is right around our median home price, you're typically looking at about $20,500 for the executor fee and another $20,500 for the attorney fee. Then you've got court fees, the probate referee appraisal, and other miscellaneous costs usually add another $1,000 or more. So all in, you're looking at around $42,000 in total costs, and all of that gets deducted from the estate before any inheritance is distributed to the heirs. And remember, if you price the home wrong, let it sit on the market too long, or delay the process, those costs can actually go up. Time is money in probate, and that's why working with someone who understands both the probate timeline and the local Central Coast market is absolutely critical. Okay, here's the big one. This is the single biggest factor that determines how fast and smoothly your sale is going to go. It's about what kind of authority the court grants the personal representative under California's Independent Administration of Estates Act. We call it IAEA for short. There are 2 types of authority, and the difference between them is night and day. Full authority. First, there's full authority. This is the gold standard. With full authority, the personal representative can list and sell the property just like a normal real estate transaction. It's faster, it's more private, and it's way less stressful for everyone involved. When we work with families who have full authority, here's what happens. We help you sign the listing agreement. We open escrow just like any other sale. We handle all the required disclosures and notices. We market the property to get you top dollar, and then we close escrow seamlessly. No court hearings, no newspaper publications, no delays. Then there's limited authority. If the personal representative only has limited authority, the sale process looks very, very different and a lot more complicated. Here's what you have to do. First, you've got to get the home appraised by a probate referee, not just any appraiser, but one specifically appointed by the court. Second, you can only accept an offer that's at 90% or more of that appraised value. Third, you have to publish the sale in a local paper like the San Luis Obispo Tribune for 3 consecutive weeks. Fourth, if you wait for a court hearing to confirm the sale, and at that hearing there's a potential overbidding process, meaning other buyers can show up at the courthouse and outbid your accepted offer right there in front of the judge. And finally, you need a court order to finalize the sale. The whole process can add 2 to 4 extra months to your timeline, plus a ton more paperwork, stress, and uncertainty. That's why one of the first things we do when we work with a family is coordinate closely with their probate attorney to help secure full authority whenever possible. It makes all the difference. Now, here's a shortcut most people don't know about because it's relatively new. As of April 2025, California raised the small estate limit, and this is a game changer for a lot of families here on the Central Coast. The entire estate, including the home, is valued under $750,000. You may qualify for California's small estate affidavit. And what that means is no court-supervised probate is required at all. But there are 3 conditions that have to be met. 1, the property must be valued under $750,000. 2, it must have been the decedent's primary residence. And 3, 40 days must have passed since the date of death. If you qualify, you just submit the paperwork, no hearings, no months of waiting, no $41,000 in attorney and executor fees. It's a huge savings in both time and money. We can help you assess whether your situation qualifies, and we can provide you a broker price opinion to keep your valuation accurate and compliant with the law. So you might be wondering, Owen, what exactly do you and Camille do to help families through this? Great question. Let me break it down. First, we provide that early broker price opinion, or BPO, so you know exactly what your home is worth right out the gate. That helps you plan accordingly, whether you're aiming for that small estate exemption or you're going through full probate. Second, we coordinate everything, and I mean everything. Cleanouts, repairs, estate sales, staging, professional photography, videography, and even remote showings if family members are out of state or out of the country. We've worked with families from all over, people who inherited here but live in the Bay Area, Southern California, or even out of state. Third, we communicate clearly with your probate attorney, all the heirs and the court, so nothing falls through the cracks. Probate has a lot of moving parts, and we make sure everyone's on the same page. And fourth, we sell the house faster and for more money because we know the market inside and out. Whether the property is in Atascadero, Arroyo Grande, Morro Bay, or right here in San Luis Obispo, we are your boots on the ground. Look, we know this is a tough time. You're grieving, you're dealing with family dynamics, and now you've got this complicated legal and real estate process on top of it all. Our goal is to take as much of that weight off your shoulders as possible, so you can focus on what matters, honoring your loved one's memory, and taking care of your family. Navigating probate is tough, but you don't have to do it alone. We created a free probate seller guide specifically for families here in San Luis Obispo County and in California. It covers everything we talked about today: the timeline, the costs, full versus limited authority, the small estate exemption, plus checklists and insider tips and resources we've gathered from years of helping families just like yours. Just head to the landing page below, fill out the short form, and we'll email it straight to you. No strings attached, no sales pitch, just helpful information when you need it most. If you found this helpful, would you do me a favor? Give this video a thumbs up, hit that subscribe button, and share it with someone who's going through the probate process right now. It might be exactly what they need to hear. And if you're ready to talk through your specific situation, reach out. You can find our contact info in the description below. We're here to help with clarity, compassion, and results. I'm Owen Schwaegerle, and we help families sell probate properties in San Luis Obispo County. Thanks for watching. We'll see you on the next video.